So for those involved in bill drafting in California, there's, and in other states for that matter, there's often discussion about what phrase should be used. Should you do a broad notwithstanding statement, or should you specify specific code sections? So we often find in California statutes and in statutes of other states, perhaps an opening phrase that begins with notwithstanding any other provision of law. In other instances, we might find a phrase such as except as provided in subdivision X. So which phrase should be used? Should either be avoided or one preferred over the other? Well, in some states, they actually try to avoid the term notwithstanding to express a limitation of a general provision of an act. For example, the state of Utah, in its bill drafting manual, it actually says that the term notwithstanding is often used as a shortcut to avoid conflicts with other laws. I think that's a true statement. Certainly here in California, we do it for that purpose. Utah's bill drafting manual goes on to say, it is preferable for a drafter to rewrite the section so that there is no conflict. If a conflict cannot be avoided, a drafter should specify the existing section that is in conflict and indicate that the provisions of the bill supersede that section. It's important to be as specific as necessary to explain which provision is being superseded. Only if it is impossible to specify a section that is in conflict should a legislative drafter state that the section supersedes conflicting sections. Now, California doesn't take as narrow a view as Utah and some other states. Both of the phrases are used throughout California's 29 codes. In fact, I found reference to the notwithstanding any other section of law to be rarely used section of law. However, there are more than 2,500 code sections that use the phrase notwithstanding any other provision of law. On the other hand, there's about 1,400 sections, code sections, that use the phrase except as provided in subdivision, and then that subdivision is specified. So really, we could say we use both of them in California, but obviously prefer the notwithstanding any other provision of law when perhaps there are too many specific sections to actually list.